Hello, everyone, and welcome to our latest AFGE Local 17 Town Hall podcast. We're always working to bring you, our members, discussions on the topics that matter most to our members based on the emails and phone calls we receive. One issue that continues to top the list is reasonable accommodations, how to request them, what to expect, and how to navigate the process effectively. To help us break this all down, we're honored to have Sarah Hazan, Staff Counsel for the National VA Council with the American Federation of Government Employees. Sarah has been with AFGE since 2013, starting as an EEO attorney with AFGE's National Women's and Fair Practices Department before joining the AFGE General Counsel's Office in 2020. Sarah is one of Local 17's favorite attorneys because she conducted a 2-day training for our stewards just before the pandemic that was absolutely fantastic. She has a deep understanding of federal labor law and a great way of breaking down complex topics into practical, real-world guidance. Sarah earned a BA from the University of Virginia and got her JD from George Mason University. After law school, she worked in New York City, specializing in civil rights litigation and employment law. We're thrilled to have her with us today to share her experience on obtaining a reasonable accommodation, an issue that affects so many federal employees. So, Sarah, welcome.
Hi, Doug. Thanks so much for having me. I'm happy to be here.
So, Sarah, could you have a wealth of experience with reasonable accommodations as an EEO attorney and as a staff counsel for NVAC. Could you briefly explain the process? So if you're an employee and you're thinking, I think I need a reasonable accommodation, what would be the first steps you would do?
Yeah, absolutely. I would first kind of understand the framework within which reasonable accommodations are offered, which is under the purview of the Rehabilitation Act and the Americans with Disabilities Act. Federal employees are entitled to reasonable accommodations that would help them better perform the essential job duties of their position. In order to qualify for a reasonable accommodation, you do have to have a disability that meets the definition of a disability under the ADA. And it's important to note that the definition of disability can vary from statute to statute. So we're not looking at the DMV definition of disability, whether or not you're service connected with VA. We're looking at specifically the definition of disability under the Rehabilitation Act and the ADA, which is that you are an individual who has a physical or mental impairment substantially limiting a major life activity or major bodily function. So as long as you can meet that basic definition of disability, which is a very easy definition to meet in most circumstances, you now are someone considered disabled and therefore are entitled to request a reasonable accommodation. So that's the first thing, do you even get your foot in the door as far as requesting an accommodation? Once that threshold is met, you're going to kind of figure out in a common sense fashion what kind of impairments related to your disability are affecting your ability to do your job effectively and fully. So based on that kind of unique analysis, you're going to either make an oral or a written request for a reasonable accommodation. And I want to point out here that there is no set of magic words that you can use. You don't have to even say reasonable accommodation, although as a best practice, you do want to identify that you are in fact seeking a reasonable accommodation. And then again, the law does not require that you make a written request for an accommodation, but a best practice is to make a written request for accommodation. For VA's purposes, VA has a form that allows you to make a written request for accommodation. That's VA form 0857A, I believe. So if you think that you're going to need an accommodation and you have a good relationship with your supervisor, you might want to broach that conversation informally before making a formal request, but you can certainly do so at the outset with that formal request for accommodation.
All right. And there's, I've gotten a lot of questions. People they have anxiety because they don't want their supervisor to know about their disability. So can you walk us through that? Because I know that supervisors are not supposed to see that information.
Absolutely correct. So bear in mind that the VA does have a handbook on requesting accommodations, and that handbook is VA Handbook 5975.1. So employees who are about to navigate this process should generally familiarize themselves with the handbook, because that will outline exactly what roles and responsibilities the supervisor has as compared to the Reasonable Accommodation Coordinator, or the RAC, and LRAC for the Local Reasonable Accommodation Coordinator. So in general, supervisors are authorized to be the deciding management official, or the DMO, on a request for accommodation. That means that they're going to be the ultimate yes or no, we can grant this accommodation. Now, simply because they're a DMO does not mean that they're entitled to any specific medical information related to your condition. And in fact, even the VA's form requesting an accommodation emphasizes that no medical diagnoses or conditions should be identified on that form. It should simply identify limitations that you have. Any medical information that's required should only be communicated to the local Reasonable Accommodation Coordinator if and when that contact is made by the employee. So it's really important to note that to safeguard your own personal information, as well as your rights as an employee, you should not be disclosing any kind of medical information to your supervisor directly. Certainly, you should not be providing any medical forms or records to your supervisor. And even the reasonable accommodation request needs to, in a very basic and limited fashion, identify only the limitations that you have related to your disability, as opposed to your diagnosis or the disability itself.
Yeah, and I remember hearing, I don't know if it's true, that if, say, for example, the LRAC discloses your disability to a supervisor, is that a per se violation of the Rehabilitation Act, like automatic, and then you go for damages? Is that?
Absolutely, absolutely. If you have evidence that your disability was disclosed outside of a need to know situation and outside with your consent, you absolutely have a cause of action under the Rehabilitation Act for a per se violation. Now, that can be filed through an EEO complaint or a local grievance at the employee's discretion, one or the other, not both.
Okay. And also, we've dealt with this at Local 17. I remember there was an arbitration where somebody wanted full-time telework for a orthopedic disability. And the VA's defense was, well, you don't get the accommodation of your choice. And in that particular case, the arbitrator did decide for the employee, because he determined she could do the essential job functions at home, and there really wasn't an alternative accommodation. So it wasn't, it wasn't like her top choice, and there was something that could be effective. But that's not always the case. But could you talk a little bit about how people aren't going to get the accommodation of their choice if something else is effective, is going to effectively overcome the barrier of their disability?
Yeah, I think that's a great point. When we talk about accommodations, we often see it from the employee's perspective only, that they're requesting a particular accommodation, which is going to be effective. We don't always consider the fact that there might be alternative accommodations, which are also equally effective in allowing them to do the essential job duties. But that's really what it's going to come down to, and in order to successfully obtain and keep an accommodation, you're going to have to work with the agency to balance their needs against yours. And typically, in an ideal scenario, the effective accommodation that you conclude, that you reach, is going to be one that is obtained through an interactive process between the employee and the agency. And the term interactive process is a legal term of art. It actually, there's a ton of case law about what the interactive process means, but it is designed so that employees and the agency can better understand the relative needs of the other party, so that different alternatives can be discussed. The viability of those alternatives can be discussed, whether there's any undue hardship present for the agency in offering some accommodations. And then ultimately, based on that interactive process and what's hopefully a reasonable discussion, the agency will be able to offer the accommodation that is both effective and also desirable to the employee. But absolutely, the law has consistently stated that employees are not entitled to the accommodation of their choice. So when requesting an accommodation and working with your provider to identify limitations at work, you need to be cognizant of the fact that, you need to be able to, explain kind of what the limitations are and identify potential accommodations. If you identify just one accommodation, it's possible that the agency would reject that, and then you're left with nothing. So keeping an open mind when you start this process and not limiting yourself to, I just want, let's say full-time telework as an accommodation. that's gonna make place you in the best position to get an effective accommodation for yourself. So, it's rare that a single accommodation is the only accommodation that's effective. And as a resource for employees in trying to figure out, like, well, what kind of accommodations could I even ask for? There's a great website folks should go to. It's called askjan.org. That's ASKJAN.org. And the JAN stands for Job Accommodation Network. So it's a third-party site that kind of has like the how-tos on navigating reasonable accommodations. They break down accommodations based on disability, based on job limitations, and it's a really great tool for kind of getting a lay of the land as far as I've got this limitation. What are some accommodations that I might and maybe should ask for in lieu of just the one that I have in mind?
Yeah, and I was thinking the ones that we get the most are a flexible schedule. Instead of the 8 to 4 or whatever, you get a maxi flex schedule. Telework is a big one. The desk, the desk that goes up and down. And I gotta say, and maybe you can discuss this, you do have to be careful. So if you are, if you are claiming I need to telework full time, otherwise I can't do this job. Well, if your job requires you to be in the office, then that may take you out. Now, it's not just we want you in the office, but an extreme example, if you're a barista in the cafeteria, but you can't make a latte at home, right? You can't have any telework. And if that happens, they can say, well, wait a minute, maybe you can't do this job. And then the alternative is they have to look for another job you can do. It's kind of a last resort, and it may not be your pay scale. So if you're a GS11, they're like, hey, we have a job for you, but it's a GS7, and that's all we have. Can you talk a little bit about that? I mean, that's a lot to unpack, really. There's a couple issues in there.
Yeah. So I think what you're referring to is a reassignment as an accommodation. And ordinarily that is what's called the accommodation of last resort. If you're working let's use your example, as a barista in the canteen, and part of your job duties are to be there in person. And for whatever reason, your physical limitations prevent you from being there in person on a regular basis, you might say, I need full-time telework. Well, now you're not able to perform the essential functions of your job. And so you're no longer qualified for that job based on your disability. And there are no effective accommodations that wouldn't, to take away someone's essential functions of their job is considered an undue hardship for the agency. They wouldn't be required to accommodate you. In that scenario, what you're looking at is a reassignment, and that is considered an effective accommodation, even though it would be in a different job and it would be potentially at a lower pay scale. And the way to navigate that process is to make sure that, number one, there really are no other accommodations that you could do. Like, what if you have situational telework? Or what if you flex your schedule so that you can take brief periods of rest? There might be something else that allows you to do that job still. Assuming that there isn't, and reassignment really is the only option that's in your favor, you want to make sure you have an updated resume. You want to make sure that you tell the agency, here are some jobs that I would be qualified for, that I'm eligible for. Can you please do a search for that? The agency is then required to take your resume and the information you've given them and do a nationwide search and offer you a job, not just within your commuting area, but even potentially in a different place, assuming that you want to take that job. But that should be up to you as to whether or not you would like to, get a transfer somewhere else. So reassignments are not desirable, but they can save people from losing their job altogether. And you want to make sure the agency does it right by really taking into account the types of jobs that you're looking for, what you're qualified for, and then if you need an accommodation in that position, what those accommodations might look like. And I want to also emphasize that reassignments are not done through the competitive process. They are just, directed reassignments for administrative reasons. And so you don't have to compete with the general population, when you are reassigned. So that's helpful as well.
Yeah, that example I gave, it kind of was a real world example. That happened at Local 17, where there was somebody at central office, I think it was VHA, and she had to come in. She came in one day a week, and she couldn't come in because of a disability. And I remember I think what happened was they gave her a reassignment to a lower graded position, and we challenged that. We took it to arbitration, and I think the reasoning was the senior executive said, we need her in the office 1 day a week. And they came up with some bizarre excuses like, oh, I need her to get the paper from my printer, which is in the room next door, and bring it to my desk like once a week. And the arbitrator just tossed that out, and he thought that was pathetic. Also, there was another case where this was bizarre, where at a grievance meeting, step 2, management came with some data, and they said that 49% of her duties require her to be in the office, but she can do 51% at home. Now, right there, like, why not 50-50? And what was bizarre about that is a lot of her co-workers, this was at an education VBA, a lot of the people that did the same work were actually remote, or they were in Atlanta. And this was bizarre too. They said, well, the accommodation will give you not full-time telework. You can do 1 week of telework, 1 full week, but the second week of the pay period, you got to come to the office. So at arbitration, the question was, well, wait a minute. If she needs to, can only do half her work in the office, half at home, that whole week in the office, that means she won't be able to do 40 hours of work, or no, at home while she's teleworking, because she can only do 50% of her job. That doesn't make any sense. And it just kind of unraveled. So what we see is, they create these essential job functions where you need to be in the office. And arbitrators, it's very easy to issue a decision saying no, but when you're before a neutral third party and you have to answer questions, things kind of change. Have you noticed that in your career?
Yeah, absolutely. I think I think what you mentioned is really spot on as far as what the agency says doesn't control as far as what is an essential job function. The PD can say what it says. The managers can testify the way they want to, but ultimately what qualifies as an essential job function is going to come down to what the employee actually does and what the arbitrator or an EEO judge determines to be essential. So based on the testimony of this person, as well as comparators who perform the same position, here's what I think is really essential to this position. So you take into account, some of the testimony of managers and some of what the job duties are, but ultimately, if management is saying that in-person attendance is an essential job duty, and you have ways to poke at that or challenge the credibility of that, you're going to introduce your, counter evidence to that. And it can weigh in your favor because arbitrators are not bound by management's determination or assessment or the four corners of that PD. There's a lot more evidence that can go into it that can help your employee explain really what is essential and what isn't.
Yeah, so that situation, it ended well. She did have to take a lower graded position temporarily to a 7. Steve Eckerman did an amazing job at the arbitration. So she was given back pay, reinstated to her prior job, 100% telework. And the other person too, she got 100% telework. But these are cases, these people were disabled. They could not come to the office. So you can't come to your union and say, listen, I have restless leg syndrome. I need to work at home. You need to have a qualifying disability. And
yeah, I mean, restless leg syndrome is absolutely a qualifying disability. So I want to just
Okay, I was kind of making a joke, but okay.
Yeah. So, I mean, I'm not a medical professional, but I want to say that I've seen ads for drugs for restless leg syndrome. So there's got to be an actual diagnosis code there, I'm sure. But a lot of times people want full-time telework. They have a disability. It does probably make it difficult for them to be in the office or to commute to the office. And in a lot of the cases where folks have requested full-time telework, it has been found that agencies are reasonable when offering situational telework. So, if your RLS is acting up one morning and you simply cannot physically get out of bed or drive into the office, maybe a flexible schedule, like you mentioned, or maybe situational telework for that day, or as it happens. So I think those are, it's not the same thing as full-time telework, absolutely. But it's not, per se unreasonable to offer something like situational telework. And there's a ton of case law on that, where employees are kind of hard pressed to explain how, why they would need full-time telework in lieu of a suggestion like that.
Okay, and also I've heard, and I think you can verify this rumor, the designated management official, the DMO, makes the decision. It's usually the immediate supervisor. And a lot of these people, they don't understand the process, and it's very challenging for them. But I heard at the Department of Veterans Affairs, they're going to replace that with some board or something like that. Have you heard about this?
I'm not familiar yet with that. I don't do EEO cases anymore in as a staff counsel, so I haven't seen that happen personally. I'm not saying that it's not going to or that it hasn't happened. But I kind of want to emphasize that the DMO is a supervisor under most circumstances where they are saying yes or no, the accommodation can be offered. But that is really that's like kind of like the final piece of the puzzle. Up
Mhm.
until then, employees are most likely interacting with the local reasonable accommodation coordinator. And the local reasonable accommodation coordinator, after, that interactive process and after meeting with the employee and understanding the medical documentation, they might make a recommendation or two to the DMO and say, look, I've got the medical information. You don't need to know it, but my assessment is that here are the accommodations that were requested. Here's what we think might be alternative, accommodations. Knowing your work unit, the type of work this employee does, is it possible? Yes or no? And at that point, that's where the DMO kind of says, yes, I can grant the accommodation, or no, I can't. They ultimately are going to be supervising that employee. They know the work best as far as what's essential, what's not essential. So that's why they are the decision maker for the accommodation. But it's not without, a ton of involvement with the LRAC and potentially suggestions from them as well.
Yeah, and the way when you were speaking, correct me if I'm wrong, I kind of view it as the DMO, the immediate supervisor, their job is they know what the employee does. They know the essential job functions.
Right.
LRAC knows the disability.
Right.
So if somebody wants a flexible schedule, the LRAC will be like, well, based on the medical evidence I've seen that you're not seeing and you should not see, this person needs a flexible schedule. And the supervisor can say, okay, this person can do the essential job functions with this schedule. Yes, it's approved. Or if it's, say, a call center and you got to be there at certain hours and that's whatever, very firm, or canteen, restaurant work, you got to start a certain time, they can say, no, actually, the essential job functions require this person to be here because we need coverage to serve our customers. So this is not going to work. And that way, it kind of like there's that wall between the supervisor and the LRAC that nobody knows what the disability is, and somehow a fair determination gets made. Hopefully, a fair determination gets made. Is that kind of how that is?
Absolutely. That's the reason why you have the medical information kind of being siphoned off and away from the decision-making faction of it. The decision about what accommodation is effective should not take into account the type of disability the employee has. The deciding management official, the supervisor, really only needs to know, how is this employee having a hard time getting their work done? And is this accommodation that the LRAC is suggesting or the employee is requesting, is that something I can do? I can still supervise this employee effectively. They can still get their job done. Or does it present an undue hardship for me? And if it does present an undue hardship, that's another legal term of art. At that point, the agency is entitled to decline that accommodation. I want to point out that VA policy makes it pretty clear that before a declination letter is sent to an employee concerning a requested accommodation, it does have to clear either the National Reasonable Accommodation Coordinator or the Office of General Counsel. So there has to be a third set of eyes now before a reasonable accommodation can be declined and communicated to an employee. Just one last final check to see whether or not there are any.
Oops. I think we lost you, Sarah, for like a couple of seconds. That's all
Oh,
right.
sorry. What did you hear last?
We just a couple seconds. I think we got most of it. It was
Okay.
just very
So
brief.
yeah, I was just going to say that employees should be aware that before their accommodation is denied or declined, the agency is required to clear that through Office of General Counsel or the National Reasonable Accommodation Coordinator, and that's per the Handbook 5975.1.
Great. I think I have two more questions, and this is a good way to transition. When, so if you're thinking, I need a reasonable accommodation, I think I'm going to apply. When would you involve the union? When would you call? So if you're at VA Central Office, when would you contact Local 17 in that process?
I would say immediately. The sooner that the local's involved and informed and can assist you, the chances of your RA going smoothly are probably going to increase. And then if there's any hiccup down the road and you actually need to file an EEO complaint or a grievance, the local has been involved from the get-go. The only kind of caveat I want to make is that the union is not the employee's exclusive representative when it comes to reasonable accommodations and EEO matters in general. So in order to have union involvement, you don't have a statutory right to have the union there because they are not the exclusive representative in this forum. So you would have to specifically designate someone from the union as your EEO representative in order to authorize them to be involved in those discussions, be your advocate, and potentially represent you thereafter. So as far as the EEO process goes and RAs, which are a part of it, the union is not recognized as a party to any of these proceedings, and is not the exclusive representative. So the union doesn't necessarily get to go, but your EEO rep should get to go, and you are entitled to an EEO representative of your choice. And that's kind of important to emphasize that even though you're working with a union, they're wearing a different hat in this particular forum.
Yeah, and just to make a point is that if you're denied a reasonable accommodation, you can file an EEOC complaint. And what Sarah just said, you can get your own attorney. However, you can also file a grievance, and Local 17 deals with that. And a few differences are that when you go to the EEOC route, it's a different process, different procedure, and you can get money damages, compensation damages. If you go the grievance route, there's the back pay, like the individual who got downgraded from, I don't know if it was a 9 to a 7. The cases we've taken to arbitration, we've explained well, if you're not looking for money damages and you want to get this done quicker, we can file a grievance and take this to arbitration. But it's really up to the individual to decide what form they want to go. And whatever form you decide, that's the one you have to stay with. Is that correct?
Absolutely. So the forum in which you file is going to be the forum you're stuck with. So whether that's filing a grievance through the union within 30 days of a denial of an RA, or whether that is filing a formal complaint of discrimination, either of those two is going to be considered your election of remedy, for that point. I want to emphasize that you can always initiate EEO contact and start the informal process within 45 days. And that informal process is not binding. So during that informal process, if you decide to file a grievance or, change your mind, you can do so. So that commitment to the EEOC process doesn't happen until you file a formal complaint of discrimination. And I just want to emphasize that the same remedies that are available to you in front of an EEO judge should be available to you in arbitration as well. So if you have sufficient evidence that warrants compensatory damages, an arbitrator should be able to award that because they would be bound by the same case law the EEOC judges are, and they would have the authority to issue the same kind of remedy as well. And as Doug mentioned, it's important to note that the EEOC, while experts in this area of law, are inundated, right? So your case is most certainly going to take at least a year before it's resolved, whereas arbitration is a much faster process, and one that the local has a lot more say in, simply because you can have you can influence, I guess, or decide who to pick as an arbitrator, and you can look for somebody who has that experience in EEO law if you want to, and you don't get your choice of an EEOC judge. So there are several pros and cons to discuss with the local when deciding, but ultimately, yes, it is the employee's choice.
Yeah, and I was thinking the one employee with the orthopedic disability that we got our 100% telework, the arbitrator, when he walked in the room, he had a cane. And I remember thinking, well, this is probably going to be good. So, but you never know. You never know. Well, listen, thank you so much, Sarah. You've been incredibly informative. And we're going to take this and put it on our website so people can see. And this really helps people get the information out there. And we appreciate Sarah's by the way, with the National VA Council. And I just want to say that is our bargaining council. So if anything impacts more than one local, the National VA Council is involved. And I would say it's probably the strongest council in the Federation. And it's like that because President Alma Lee, who's been the president for over 35 years, and the 3 executive vice presidents, we have MJ Burke, Oscar Williams, and Bill Wetmore. And we're very grateful for NVAC and allowing us access to Sarah and the other attorneys. So thank you, Sarah. We appreciate it.
Thanks so much, Doug. Have a great day.
All right, you too. Thanks. Okay, everybody. Thank you. By the way, we do these podcasts. We pick the topics based on what we receive, the feedback from you, your emails, your phone calls, your text messages. And we did one recently. Last night we did the telework one. I apologize. I indicated that we're going to have one at 7 o'clock, thinking maybe we would reach capacity and do another one at 7:45. For those that were waiting at 7:45, I can do a conference call. We can do something else to get that information out there. But anyways, we appreciate our membership and we appreciate your support. And without you, we can't be effective. So thank you very much. And we'll be talking to you soon. Take care. Bye-bye.